Good afternoon, sir.
So, good afternoon, everyone. Today, I am planning to complete. I mean, uh, not only the topics relating to quashing and evidentiary value, but also a case law. Case law. So, I will be going little faster. So please refer to the PPTs which I have shared on your Google Classroom. And if you happen to encounter any doubt, then drop me an email or you can ask me in tomorrow's class, as we have two classes tomorrow. I will join at 2 and I will teach for the entire 2 hour duration tomorrow, because we need to complete 4 cases tomorrow, 3 to 4 cases tomorrow. So let's start today's discussion. Yesterday, we were discussing quashing of FIR. After discussing certain issues which are involved in law relating to FIR, we reached up to the stage of quashing of FIR. And this is one area which is actually used in criminal law litigation. That when an FIR is filed against an accused person, if the accused person is resourceful, then he or she shall definitely take this shot. That please, he or she would definitely request his or her lawyers that please look into whether this FIR could be quashed at this stage only. Because if an FIR is quashed at the outset, then you are uprooting the entire criminal process in the initial stage of the criminal proceeding. So you don't have to bother about police investigation after that. You don't have to bother about filing of charge sheet after that, and there is no worry relating to arrest as well. So this is one provision which is very dear to people with money under criminal justice system. This topic, quashing of FIR, and which can be done by filing a petition under 482. So idea would be when you will ask your lawyer to do something which can completely uproot the entire case against him or her, is कि यार फाइल करके तो देखो, जो होगा हो जाएगा. Ultimately, what would happen? कि the High Court would say that this is not a fit case to quash your FIR. There also you can move to the Supreme Court under 136 by filing a SLP. So you can complete that full circle. If you have 4-5 lakh rupees in your pocket to pay the fees of a good lawyer, then you can easily file for quashing before High Court, and then you can go up to Supreme Court by filing a SLP against the impugned order of the High Court. So in state of Haryana versus Bhajanlal, Supreme Court laid down certain circumstances in which an FIR or a complaint. When I am saying quashing of FIR, it also includes quashing of criminal complaint as well. So do not think कि आप criminal complaint को quash नहीं करा सकते हो, बस FIR को ही quash करा सकते हो. It includes, when I am saying quashing of FIR, this expression includes within itself quashing of complaint, criminal complaint as well. So in this Bhajanlal case of 1992, Supreme Court gave an illustrative list of circumstances in which high courts are empowered to quash an FIR if those circumstances exist. But do remember that it's an extraordinary remedy, so therefore it cannot be exercised in a regular manner. It has to be exercised very cautiously as well as very carefully, because if you are ordering that FIR should be quashed, then in that situation, there is no criminal case against the accused at all. He or she will be kind of a free man in the nature that it will take him back to a situation where there exists no criminal case against that accused person. So the first circumstance in which FIR can be quashed is that where allegations made in FIR or complaint, if they are taken on their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused person. So here what the court will do, court will read the FIR and court will treat each and every word written in the FIR as true. And even after doing that, if court comes to this conclusion that by reading this FIR, it cannot be said that accused has committed any offense. So, which means that the write-up of the FIR is such that FIR is written in such manner that it is not any disclosing any case committed by any offense committed by the accused person. This was the ground reiterated by Supreme Court recently in Arnab Goswami case. So when Arnab Goswami was arrested on the basis of an FIR filed against him, so he approached the High Court. Then High Court did not give him the adequate relief, so he approached Supreme Court. In Supreme Court reiterated this first illustrative circumstance given by Bhajanlal case, and held that if we read the FIR, then it seems that there is a case against the accused person. It seems that the complainant or the informant is clear enough to make a case against the accused person. Rest would be stated later on when investigation would conclude in this case, but it is not a fit case to question FIR. Now, second circumstance is that where the allegation in FIR and other material. So the difference between first and second one is that in the first circumstance, the judge is relying only on the FIR. But in the second circumstance, judge is relying on not only the FIR, but also some other material which are accompanying the FIR. Which means that suppose you are approaching the court at a stage where some part of the investigation has already been conducted, or you have some material to show to the court that please look at this material as well. And when you look at both the FIR as well as this additional material, then they do not disclose a cognizable offense. So the idea of the second circumstance is, first wale mein tha, accused has not committed any offense. It is a material, whether it was cognizable or non-cognizable. But in the second one, what is material is by looking at the FIR and any additional material. So I cannot comment on it that what is going to be that material on which the petitioner would rely before the High Court in a quashing of FIR wala petition. So if they do not disclose any cognizable offense, and if there is no cognizable offense, then there is no justification of conducting an investigation. So therefore, it is also a fit ground or circumstance to quash the FIR. Third one is that where the uncontroverted allegations which cannot be substantiated and the evidences collected in support of the same do not disclose the commission of the offense. So this is a stage which is coming a bit later. You are filing the quashing of FIR under 482 at a stage when the investigation has been completed up to a level, and now you have more material to show to the High Court that look, your lordship, on 1st January 2019 an FIR was filed against me. Now police started investigation on this FIR. Now at this point of time, for example, you are filing it in April. From January to April, all the evidences which have been collected by the police, they are not disclosing any commission of an offense, or they are not making a case against me. So therefore, please quash this FIR. This could also be a ground to quash the FIR. So these all are technical, very technical circumstances. If you read them closely, तो फर्स्ट वाले circumstances में judge is reading only the FIR. Second वाले circumstance में judge is reading FIR plus some other material. I cannot comment on what could be possibly that material. I have to read certain case laws on which second circumstance has been used to quash the FIR. Third is judge is not only looking at the FIR, but judge also has certain up to a certain level the material relating to investigation available to him, and on the basis of both FIR and the evidences collected during the time of investigation, if he finds that no cognizable case is made out against the accused person or accused has not committed any offense, then he can quash the FIR. Fourth is where the allegations in the FIR do not constitute a cognizable offense but constitute only a non-cognizable offense. This is slightly different. It's very simple also, that by reading the FIR, by only reading the FIR, if the judge of the High Court is coming to this conclusion that it is disclosing an offense, FIR is disclosing an offense, but the nature of the offense is non-cognizable. So therefore, if the nature of the offense is non-cognizable, then no FIR can be filed, reading 154, 155 together, and hence it should be quashed. FIR which has been filed should be quashed. Next circumstance, fifth one, is where the allegation made in FIR or complaint are absurd or inherently probable. Now, as far as this ground is concerned, it is very wide. What is absurd, what is going to be inherently probable, on the basis of which no prudent person can ever reach a just conclusion, all these things depends on the kind of circumstances which you are bringing forth before the court. So for example, if the FIR states that A killed B, and if A is able to prove that, look, your lordship, I was not even in India at that day, so therefore this is completely a baseless allegation. I was somewhere else. For example, a plea of alibi which you may take at the time of the trial. If you have that plea of alibi which is very strong in nature, which could prove to be very conclusive, so then you can take it at the time of quashing wala petition. But as far as this ground is concerned, it is very wide. It gives a very huge latitude to a High Court judge. If suppose a High Court judge is favorable to you, he can use this circumstance to quash the FIR and let the state go in appeal in Supreme Court. Let the state go in appeal in Supreme Court and let the Supreme Court overturn the decision of the High Court. You can give a small relief, or you can give a relief for a small period of time to the accused person. You have this capacity under these circumstances, because some of them are very open-ended. For example, fifth one, where allegations made in FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent person ever reached blah 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 blah, and then you can quash the FIR. Now, sixth one is where there is an express legal bar and engrafted in any provision of the code or the act concerned to the institution and continuance of proceeding, and where there is a specific provision in the code or the act concerned providing efficacious redress for the grievance of the aggrieved party. So it will take care of such situations wherein CrPC has certain provisions. For example, if you want to file a case relating to offenses in marriage or offenses relating to marriage, then the complainant must be either the wife or some relative of wife. So imagine a situation if someone else has filed a complaint relating to offenses against marriage, so that is not allowed under CrPC. So in that particular case, that complaint shall be quashed. So it is talking about a situation that if before filing an FIR or before filing a complaint, the magistrate or police are required to take some consent or permission, or magistrate or police are required to see that who is the complainant or informant, then in that particular case, if such procedural requirements are not followed, then FIR shall be quashed. The FIR shall be quashed. And the last one is where a criminal proceeding is manifestly attended with malefides. The kind of question which I asked you at the outset, that if A comes to you that an FIR has been filed, if Y comes to you that X has filed an FIR against him with a malefied intention only to harass him with some ulterior motive, then this could be a reason to quash the FIR or complaint. All these circumstances are kind of illustrative in nature. They are not exhaustive circumstances. High Court is free to question FIR on any ground other than these 7 circumstances. However, these 7 circumstances have been drafted in such an intelligent manner that since 1992 they are consistently being followed by not only all the high courts but also by the apex court. Bhajanlal is one case which is regularly cited by high courts and Supreme Court when it comes to deciding an issue relating to quashing of FIR or quashing of complaint. So quashing wala topic is one area of criminal law which is beyond your classroom, which is slightly beyond your classroom, because normally what happens in classroom, we are mainly concerned with the theoretical aspect of the CrPC, mainly concerned with. I'm not saying what all we discuss relates to theoretical perspective of CrPC, but by and large, for example, kitni copy hongi FIR ki ya sign hogi FIR ya nahi hogi, these are some theoretical procedural requirement. But when it comes to day-to-day litigation kind of cases that comes to the court, then this is one area which should be read in its entirety by every person who is reading CrPC. So what I have done is making a foundation for you. Now it is up to you how much you want to build upon that foundation, how many cases of quashing you want to read, and you want to have a clarity about different grounds given by Supreme Court in Bhajanlal case. So there is no need for now or for the purpose of your exam to know each and every circumstance in a very clear and in a very elaborate manner. You just need to know that such a concept exists under CrPC, that an aggrieved person, if he or she thinks that FIR has been filed or complaint has been filed against him or her to harass him, to unintentionally implicate him in a criminal case, then this remedy is available to each and every person. However, there is a practical difficulty in getting such kind of remedy, because when we say that a remedy can be sought only from High Court or Supreme Court, then you need to have a deep pocket to approach those courts. That is why whenever somebody calls me कि भाई ये हो गया इस मामले में क्या करें, so if that person is calling me from my village or from a nearby area and I know his economic capacity, then I am not going to tell him this, that file a quashing of FIR petition before the High Court, because I know personally that person does not have the capacity to approach the High Court and to sustain a litigation in the High Court. What at most I could tell him, you can talk to the IO bhai. If IO is ready to file the charge sheet otherwise, or to file a final report, then you can have some relief from this case law. Otherwise you have to go with the case law. So this is a rich man's remedy. Quashing of FIR is a rich man's remedy. It is not a remedy that is available to each and everyone. Now coming to evidentiary value of FIR. Now, when it comes to this topic, that what is the evidentiary value of FIR? So what we will try to discuss under this topic is कि भाई ये जो आपने रिपोर्ट दर्ज कराई है, it's a document, it's a documentary evidence of something. Okay? Now the question would arise, how will you use this FIR wala document during the trial? Because during the trial, evidences will be taken from both the sides, from the prosecution and defense side. Both the sides will be given a chance to cross-examine the evidences, to counter the evidences given by either of them. And finally, on the basis of the entire gamut of evidences, the court is going to decide the guilt or innocence of the accused person. So the moot question which we should, whenever we want to discuss evidentiary value of FIR, should be is जो statement का which has been given by the informant to the police, इसका relevance क्या है at the time of trial? Evidence Act के किस section के अंदर ये relevant, as it can be taken as a relevant evidence? or it will be a relevant evidence under which section of the Evidence Act. So for understanding this, you have to divide this topic into three. So first, what you will do, discuss it under three heads. So first, you have this clarity that I am going to discuss this topic of evidentiary value of FIR under three heads. These three heads would be dependent on who is the informant, who is the person approaching the police station to lodge an FIR. So it could either be a victim can approach the police station and lodge an FIR. It could either be the accused person, or it could be a third person. So depending upon who has lodged the FIR, who has approached the police to lodge an FIR, you will decide the evidentiary value of that FIR or that document. So first we will take up what is the evidentiary value of FIR if it is lodged by victim. So we have divided this topic into three. So I will be telling you the same statement in each of the parts. So first question that we are answering is that what is the evidentiary value of an FIR which is lodged by a victim, So the first provision of Evidence Act under which such FIR could become relevant is under 32. And it is the only situation wherein FIR can be used as a substantive evidence. Otherwise, FIR will be used either as a corroboratory or contradictory evidence. It cannot be used as a substantive evidence. So that discussion of difference between substantive and corroborative you may have in your evidence class in detail. But the basic idea here is that FIR, except in one circumstance, cannot be used to decide the guilt or innocence of the accused person. उसके बेसिस पे आप किसी को सजा नहीं कर सकते हो, आप किसी को guilty नहीं decide कर सकते हो, ना ही innocent decide कर, only on that particular evidence. So that is why it is not a kind of a substantive evidence that can be used to decide the case. It can be used to corroborate a substantive evidence or contradict a substantive evidence. So it is itself, FIR itself is not a substantive evidence, except in one situation where FIR is used as an evidence under section 32. So what is section 32 of Evidence Act?
Dying declaration.
It is dying declaration. Dying declaration is section 32. So I will tell you a situation. Suppose police got an information that XYZ person has committed a sexual offense against ABC. Now that information was not complete, it was cryptic in nature. So police rushed to the crime scene. Instead of crime scene, for example, take that the victim is being taken to the hospital. So police rushed to the hospital. The first statement relating to the commission of the crime was recorded by the police inside the hospital of the victim of that particular offense. And after narrating the entire ordeal, and because the entire ordeal is being narrated for the first time and the earlier information was cryptic in nature, that statement of the victim to police inside the police station would become first statement, and that is why first information report. So after narrating the entire ordeal to the police, the victim dies. So now this statement, which was first information report by the victim to the police of a sexual offense committed against her, would convert itself into a dying declaration. And hence FIR lodged by the victim by narrating the entire ordeal of the offense committed against her would become a substantive evidence under section 32 of the Indian Evidence Act. Suppose you are standing in front of Maurice Nagar police station and there is a family feud going on in your family, and your cousin comes and stabs you and runs away from the crime scene. Now, as you are standing in front of the police station, you are immediately being taken inside the police station. And the moment you are taken inside the police station, you narrated the entire scene of crime, entire scenario of the crime, that who stabbed me, and do I know that person, or whether I do not know that particular person. You narrate the entire ordeal to the police. After narrating it, you are taken to the hospital. So that narration has become a first information report. In hospital, you die. You dies. So when you dies in the hospital, that statement would become a, which you have given to the police inside the police station, would become a dying declaration. Would become a dying declaration. So just visualize, try to visualize it, that FIR in certain situations, if it is lodged by victim, may become a dying declaration. And if it has become a dying declaration, then it will be treated to be a substantive piece of evidence under section 32 of the Indian Evidence Act. Now coming to the second section, under which FIR could become a relevant evidence.
Sir, what is this substantive piece of evidence?
एक ऐसा साक्ष्य जिसके आधार पे आप किसी को गिल्टी या इनोसेंट प्रोनाउंस कर सकते हो. एक लाइन में अगर समझाऊं मैं आपको इसको, वैसे तो ये चीज एविडेंस जब आप पढ़ोगे आपको वहां डिटेल में डिस्कस करनी चाहिए. ठीक है जी. एक ऐसा साक्ष्य जो इतना स्ट्रॉन्ग हो, जो इतना पावरफुल हो, जिसके बेसिस पे आप गिल्ट और इनोसेंस का डिसीजन दे सकते हो. जैसे कि रेप ट्रायल में सब्सटेंटिव एविडेंस क्या होगा?
इंटरकोर्स, मेडिकल,
नहीं और बताओ.
स्टेटमेंट लड़की का,
स्टेटमेंट ऑफ द विक्टिम,
टेस्टिमनी ऑफ द प्रोसिक्यूट्रिक्स वुड बी ए सब्सटेंटिव एविडेंस. एवरीथिंग एल्स वुड बी कोरबोरेटिव इन नेचर और कॉन्ट्राडिक्टिव इन नेचर. समझ लो, मेडिकल को यूज करोगे आप उसके स्टेटमेंट को जस्टिफाई करने के लिए. ठीक है, कि देखो विक्टिम ऐसा बोल रहा है और ये मेडिकल रिपोर्ट है, और जो ये बोल रहा है ये कोरबोरेट कर रही है मेडिकल रिपोर्ट उसको. या फिर अगर आप डिफेंस लॉयर हो तो आप बाकी के स्टेटमेंट्स को या किसी और एविडेंस को यूज करोगे टू कॉन्ट्राडिक्ट दैट स्टेटमेंट. ठीक है, जैसे टेस्टिमनी ऑफ आई विटनेस इज अ सब्सटेंटिव एविडेंस. Confession given by the accused person before a magistrate under 164 is a substantive piece of evidence. ठीक है जी. हाँ, so बाकी आप इसको एविडेंस एक्ट में और डिटेल में पढ़ना. ठीक है. So now the second section under which FIR would become relevant is section 6. Section 6. What does section 6 talks about? Anyone? Section 6 of Evidence Act.
Sir, relevancy of fact forming a part of same transaction.
ठीक है जी. नाउ यहाँ पे रुक जाओ. जब विक्टिम FIR फाइल कर रहा है तो उससे पहले क्या हो चुका है? विक्टिम के साथ अपराध हो चुका है ना उससे पहले.
यस सर.
नाउ he or she is continuing that chain. She is continuing that chain, going to the police station after the commission of the crime against him or her. So that FIR which he or she is registering as a victim would be a relevant evidence under section 6 as well. Section 6 as well. ठीक है. Now what is section 8? Section 8 of Evidence Act.
Motive preparation.
Motive. उसके अलावा भी कुछ है क्या उसमें?
कंडक्ट सर.
हाँ, ठीक है. कंडक्ट. ठीक है. अपराध हुआ विक्टिम के अगेंस्ट में और वो FIR कराने थाने चला गया, तो ये क्या है उसका? पोस्ट क्राइम conduct. So therefore FIR would be a relevant piece of evidence under section 8 as well. ऐसे ही अगर accused ने अपराध किया और उसके बाद चला गया पुलिस को बताने के लिए that I have committed a crime for which I am really feeling sorry, तो ये क्या हो गया उसका? post crime conduct. That would also become relevant. जैसे कि आप उसमें illustration पढ़ते हो that after committing the crime the accused booked the ticket and ran away to XYZ place. So that evidence of booking the ticket and going to a different place would become a relevant evidence under section 8, showing the behavior of the or conduct of the accused post crime, after committing the crime, how the accused behaved. तो victim जैसे ही अपराध जब उसके against commit हुआ है थाने जाता है, तो it is not only forming a chain but it is also showing the conduct of the victim. So therefore FIR would become relevant under section 8 of the Evidence Act as well. This is slightly tricky. You have to read Evidence Act looking at the informant. Who is the informant? Okay? So if FIR is filed by the victim, then the statement in the FIR would be a relevant evidence under section 32. If the victim dies after recording the statement, it may be relevant under section 6, completing the chain of the facts involved in the commission of the crime, and it can also be relevant under section 8 as a post-crime conduct of the victim. Now coming to two provisions which are read together. If victim is called as a witness, isko dhyan se sunna, if victim is called as a witness at the time of the trial, which is going to be a situation in 99% of the cases where victim is alive, where victim is not dead, then in almost all trials, victim shall be called as a prosecution witness. Okay. So if victim is called as a witness, then if victim is the one who was the informant and has lost the FIR, then prosecution can use that FIR given by the victim, to corroborate the testimony of the victim at the time of the trial. This is the relevancy of FIR under 157. So FIR lodged by the victim can be used as a corroborative evidence to support the testimony of the victim at the time of the trial. I am repeating it once again. If FIR is lodged by the victim of a crime, then in case victim appears as a witness during the trial, this FIR can be used by the prosecution to corroborate the testimony of the victim at the time of the trial. That is why FIR becomes relevant under 157 of Evidence Act. Now coming to this particular situation from the side of defense. If victim is the informant who has lost the FIR and he or she also appears as a witness at the time of the trial, then defense can use the FIR to contradict the testimony or statement of the victim at the time of trial. तब तो आपने ऐसा बोला था, अब ऐसा बोल रहे हो. FIR जब आपने दर्ज कराई थी, ये रही FIR की कॉपी, तब तो आप ऐसा कह रहे थे, अब आप ऐसा कह रहे हो. तब तो कह रहे थे राम और श्याम ने आपको स्टैब किया, अब आप कह रहे हो कि राम श्याम ने नहीं, सोनू और मोनू ने स्टैब किया आपको. तो ये तो कॉन्ट्राडिक्टरी स्टेटमेंट है, तो इसका मतलब आपकी FIR ही झूठ थी बिल्कुल. ठीक है. तो द कंक्लूजन इज दैट FIR filed by a victim can be relevant either under 145 or under 157 in cases where victim appears as a witness at the time of trial. So these are the 5 sections under which the FIR filed by the victim could be relevant as a piece of evidence, and hence the evidentiary value of FIR filed by the victim. ठीक है. एक बार रुक जाओ भाई, मैं इसको कंप्लीट कर लेता हूं, just a second. ठीक है. Now second is, if the FIR is filed by a third person, then it cannot be relevant under, because third person is not a victim, it cannot be relevant under 32. It cannot be relevant under section 8 as well, because the conduct which we look at under section 8 for the purpose of relevancy of evidence is either of the victim or the accused, not of third person. But if you read section 6, then there is a illustration under section 6. When A and B is fighting, then not only the conduct of A and B, but also the conduct of the bystanders would become relevant. So suppose a fight is taking place in your mohalla, and you could not see the kind of violence that is being committed out there, and you run away to the police station to give an information. That information would become an FIR. You would say that, sir, Sonu and Monu are fighting, and Monu is about to kill Sonu. Okay? So that information would become first information report, and it would become relevant as res geste. क्योंकि जो घटना घट रही है उससे जुड़ा हुआ एक व्यक्ति, and that could be a bystander also, is going to the police station to file an FIR. Now, if you who has filed an FIR as a third person called as a witness, if you are called as a witness, then prosecution can use that FIR to corroborate your testimony at the time of trial. to support your testimony. ये देखो भाई, इस व्यक्ति ने FIR दर्ज कराई थी कि सोनू मोनू की लड़ाई हो रही है. अब जब ये अपनी टेस्टिमनी दे रहा है तो ये कंप्लीटली बता रहा है कि भाई 2-2:15 बजे का टाइम था, सोनू मोनू लड़ाई कर रहे थे, मोनू वाज अबाउट टू किल सोनू और सोनू वाज अबाउट टू किल मोनू, एंड एट दैट पॉइंट ऑफ अ टाइम आई रश टू द पुलिस स्टेशन एंड फाइल्ड द FIR. तो वो टेस्टिमनी आप जब अपनी दोगे, योर FIR का स्टेटमेंट कैन बी यूज्ड टू कोरबोरेट योर टेस्टिमनी. Similarly, defense can use the FIR lodged by a third person to contradict the testimony of third person in case the third person is called as a witness by the police. And normally ऐसा होता है that if a third person has lodged the FIR, so that third person would surely become a prosecution witness. He may turn hostile at the time of the trial, but he will surely become a prosecution witness. So that is why FIR filed by the third person is a relevant piece of evidence under section 8, under section 6 as a res geste, under section 145 and 157. Now coming to FIR filed by accused. FIR filed by accused, wherein the person who is committing the crime because of XYZ reasons could not handle the pressure that has been built after commission of the crime, reaches to the police station, gives the information that I have committed XYZ offense against XYZ person, these are the weapons which I have used, blah 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 blah. So that statement cannot be used as a confession, for example, confession. Because why it cannot be used as a confession? Because any statement recorded by the police of the accused person which is confessional in nature is not a substantive piece of evidence, is not a relevant piece of evidence. तो अगर उसी व्यक्ति ने यही बयान जो पुलिस को FIR में लिखवाया है 164 में दे दिया मैजिस्ट्रेट के सामने, then it can be used as an evidence. But FIR lodged by an accused person cannot be relevant as a confession. It will be relevant under section 21 as an admission. There is a difference between admission and confession, which you will appreciate when you will read Evidence Act very closely. Now, it will also be relevant under section 8 because it is the conduct of the accused person. Crime commit करने के बाद accused went to the police station. It is showing the post-crime conduct of the accused person. So therefore, if FIR is lodged by the accused person, then it would become relevant under section 8 as well. Now coming to this binary of 145 and 157. Now the statement given by the accused person can be used by the prosecution to corroborate his testimony. If he is called as a witness at the time of trial, defense witness at the time of the trial, then defense can use this statement to corroborate his testimony. But because of the protection given to the accused person under law relating to that an accused person cannot be compelled to be a witness against himself. So therefore, you cannot use that statement of FIR to contradict the testimony of the accused person at the time of the trial. तो अगर at the time of the trial accused कह रहा है कि मैंने नहीं अपराध किया, तो आप उसको FIR की कॉपी नहीं दिखा सकते हो कि यार वहां पे तो FIR में आपने लिखवाया था कि आपने XYZ अपराध कमिट किया था. It is because accused has been given protection under our criminal law, a procedural protection as a part of the fair trial, that only when he does his confession in front of a magistrate, that piece can be used as an evidence. Any other statement which is confessional in nature given by the accused person either to a third person or the police cannot be used as a substantive piece of evidence. So therefore you cannot use this FIR to contradict the testimony of the accused person. So but there is an exception to it. If you read 315 of CrPC, then it leaves a certain scope for FIR ka statement to be used as a contradictory evidence under section 145. So you may discuss that in detail when you will study 145 and 157. So depending on who lodged the FIR, whether it was a victim who lodged the FIR or third person or accused, the evidentiary value of FIR can be decided. So please go through this slide later on after the class carefully so that you have a clear or complete understanding of evidentiary value of FIR. और 3 में डिवाइड करके पढ़ना. अगर आप इसको एक साथ पढ़ लोगे ना, then it will become difficult to understand. और ये मेरी तरफ से भी कंप्लीट डिस्कशन नहीं है, इसमें ऐड और माइनस हो सकता है कुछ. इट डिपेंड्स ऑन हु इज टीचिंग यू. सपोज अ पर्सन हु इज लिटिगेटिंग लॉयर, क्रिमिनल लॉ लॉयर, he may add few things into it. a person who is a High Court judge, he may add few things into it. I don't think a teacher would be able to add anything else, but a practical person would be able to add few things. So that is all about evidentiary value of FIR. Now you can ask if you have some question relating to it, directly relating to it. हाँ जी बोलो.
सर ये 3rd% के केस में ये सेक्शन 8 में क्यों रेलेवेंट नहीं होगी जो FIR 3rd%?
क्योंकि भाई कंडक्ट रेलेवेंट दो ही लोगों का होता है क्राइम में, विक्टिम का या अपराधी का, तीसरे आदमी का नहीं होता कंडक्ट. जस्ट होगा हाँ रेलेवेंट.
ओके सर, थैंक यू.
ना तो उसके अगेंस्ट क्राइम हुआ है ना उसने क्राइम किया है, तो पोस्ट क्राइम कंडक्ट की बात ही नहीं आती है उसके रेफरेंस में. ठीक है
सर. सेक्शन 8 में मोटिव प्रिपरेशन भी तो है सर साथ में.
उसमें बात नहीं कर रहे हैं हम सिर्फ सेक्शन 8 के उस पार्ट की बात कर रहे हैं जहां पे कंडक्ट की बात हो रही है.
ओके सर.
ठीक है जी. सेक्शन एक्चुअली एविडेंस एक्ट इज द possibly most beautiful legislation which anybody could draft, and there are very few people who are there to teach it. I know only one teacher who can teach it well. He is teaching in RMNLU, AP Singh, but he doesn't teach. He don't want to teach. He has become so lethargic that he doesn't teach. Earlier he used to teach at Ambition for like 10-15 years back when he was a teacher at MH College Ghaziabad. So he used to come from Ghaziabad to Ambition to teach evidence and other subjects like CrPC and mainly criminal law. But after getting a job at Lucknow, it was not possible for him to travel from Lucknow to Delhi. So he doesn't teach nowadays. So he is the one person who could possibly teach evidence in a way which nobody else could do. Evidence Act is a very difficult act to handle. Coming to the case law, and I'll start it and I'll try to complete it. I still have 10 minutes with me, so I will try to complete it. Now, during our discussion on different issues relating to law of FIR under CrPC, I discussed with you very briefly that there is a issue which reads thus, that whether it is mandatory for a police officer to register an FIR if the information given to him is disclosing the commission of a cognizable offense, or the police officer has a discretion to conduct a preliminary inquiry to test the veracity of the information before registering an FIR. So there are two sides of the coin. One side of the issue is asking you a question that whether it is mandatory for the police officer to register an FIR if the information is disclosing a cognizable offense. Other is saying that whether police officer has a discretion. When he has a discretion, it means he may register the FIR or he may not register the FIR, and that discretion is in this nature, that whether he can conduct a preliminary inquiry to test the veracity of the information disclosing a cognizable offense and then register an FIR. Now, this issue became the main issue that was decided by the Supreme Court in the year 2013 in the case law of Lalita Kumari versus Government of Uttar Pradesh. Now, it was a decision by a constitution bench, 5-judge bench sit together to decide it, and decision was delivered by Chief Justice Satasium. Now, the case arose out of a writ petition. This final decision arose out of a writ petition. That writ petition was filed by a father before Supreme Court, asking it to issue a writ of habeas corpus to the state of Uttar Pradesh and Police Department of Uttar Pradesh to find his minor daughter. So Lalita Kumari is the name of that girl who went missing. Somebody had kidnapped her, who went missing. Now her father is approaching the Supreme Court for the issuance of writ of habeas corpus. बट अब आप पूछोगे कि यार रिट क्यों फाइल करने आया है, पहले पुलिस को तो FIR करा देता अपराध के बारे में. तो द एंटायर स्टोरी इज दैट व्हेन दिस पर्सन्स डॉटर वाज किडनैप्ड, व्हेन ललिता कुमारी वाज किडनैप्ड, आफ्टर द क्राइम he went to the police station asking the police officer to lodge an FIR, but police officer did not register the FIR. Aggrieved by it, He went to the superintendent of police. Now, on the order of the superintendent of police, an FIR was lodged. But even after lodging the FIR, the police did not do anything to recover his daughter or to find out the whereabouts of his daughter. Also, police did not arrest anyone. Any suspects were no suspect were apprehended by the police. Even when the FIR was disclosing certain names that I have doubts that these people may have kidnapped my daughter. Aggrieved by all these problems, he directly approached to the Supreme Court. And before the Supreme Court, luckily, the judges decided to take up this matter. They could have said, no, approach the relevant high court or approach the magistrate court. Magistrate will pass a order against the police to conduct a fair investigation in this case. But they did not do so. He was lucky enough. This petition was taken up by a division bench, and division bench issued notice to the different state governments framing this issue, that whether it is mandatory to register an FIR or police officer can exercise their discretion. So a kidnapping case now has become a legal issue inside the courtroom, inside the highest court of this land, Now, when State Government Council appeared, they told the Supreme Court that, Your Lordship, there are case laws by this court which provides that police officer can conduct a preliminary inquiry before registering an FIR. So therefore, police officer has a discretion whether to register an FIR or not to register an FIR. So they cited several case laws like P. Sirajuddin versus State of Madras, Shashikant Central Bureau of Investigation, Rajinder Singh Katoch versus Chandigarh Administration. The counsel of the petitioner, on the other hand, told Supreme Court that, Your Lordship, there are many decisions in which Supreme Court itself has held that it is mandatory for the police officer to register an FIR in case information is clearly disclosing a cognizable offense. They do not have any discretion to conduct a preliminary inquiry in case information is disclosing a cognizable offense. Now, the situation before the division bench was such that they have 3 judge bench decisions talking about both the sides. One bunch of the cases are about giving discretion to the police to register an FIR. One batch of cases are providing for mandatory registration of FIR. No discretion is given to the police. And as these cases were decided by 3 judge benches, some of these cases were decided by a 3 judge bench, the 2 judge bench in their order requested the Chief Justice to place the matter before a 3 judge bench. The matter was placed before a 3 judge bench in 2012. And this is a funny thing about Supreme Court. If the matter was so important, it was taken up readily by the division bench of the Supreme Court, then they should have constituted that 3 judge bench in 2008 only. But they waited for 4 years. In 2012, this matter was heard once again. When I joined ILI to do my LLM. So at that point of a time, it was a very popular order of a 3 judge bench. So 3 judge bench looked at the material, heard counsels from both the side, and decided that, look, the decisions which they are talking about some of them are of 3 judge bench decision. So it will not be good for us to test the veracity of all the 3 judge bench decisions which has been cited by counsels of both the sides. So therefore, this is a fit case to constitute a constitution bench. So they requested in their order Chief Justice to constitute a 5 judge bench. Ultimately, a 5 judge bench was constituted, and hence this decision. Ultimately, a 5 judge bench was constituted, and hence this decision. So this is the entire story of how Lalita Kumari started with a 32 ka petition before a division bench, went up to 3 judge bench, and now finally disposed of by a 5 judge bench. Main reason being that there are 3 judge bench decision already existing which are talking about both the sides of the coin. One is it is mandatory to register an FIR, other is it is not mandatory, police officer can conduct an inquiry. Now, after hearing counsels from both the sides, in Lalita Kumari case, Supreme Court held or concluded, and I will tell you the conclusions. Rest of the things I may discuss with you if I happen to get some time in tomorrow's 2 hour class. So what court has held, that after hearing counsels from the counsels from both the sides and reading the decisions, all the decisions delivered by the Supreme Court, we are of this opinion that if you read 154, then the true interpretation of 154, if we really want to protect the interest of the victim or complainant, and if we really want to protect the interest of the society, then under 154, registration of FIR is mandatory. This was the first conclusion given by the Supreme Court, that registration of FIR is mandatory under 154. If, and this is important, if the information is disclosing commission of cognizable offense, and no preliminary inquiry is permissible in such situation. No preliminary inquiry is permissible in such situation. So as far as first conclusion is concerned, the decision of the Supreme Court is very clear and unambiguous. It simply states that it is mandatory for the police officer to register the FIR if the information is disclosing a cognizable offense. He cannot say, I want to conduct a preliminary inquiry. Now, if the information does not disclose a cognizable offense, but it is like ambiguous information. So in order to test the veracity of that information, which is not disclosing prima facie, ex facie, on the face of it, a commission of cognizable offense, then in that case, police officer has the discretion to conduct an inquiry, to conduct a preliminary inquiry. Now, after that inquiry, if it is disclosed that a cognizable offense has been committed, then police will register an FIR. If after the inquiry, police officer comes to this conclusion that either the information is disclosing a non-cognizable offense or no offense, then he will inform the informant, police officer, investigating officer, or officer conducting preliminary inquiry will inform the informant that I inquired into your information or information given by you, and I did not find that cognizable case has been committed on the basis of my preliminary inquiry. So therefore, I am not registering an FIR. He must also disclose the reasons in brief, closing the complaint and not proceeding further. Now, police officer cannot avoid his duty of registration of offense if cognizable offense is disclosed. If he is avoiding his duty, then he can be prosecuted under section 166 of CrPC. तो कल जिसने न्यूज देखी हो, तो कल एक दिल्ली दंगों के मामले में सेशन जज का ऑर्डर आया है. तो उसमें ये हुआ था कि एक्स पर्सन वेंट टू द पुलिस स्टेशन who suffered an eye injury during Delhi riot. Now when he went to the police station to register an FIR, instead of registering his FIR, they clubbed that grievance into some other FIR lodged by them. That XYZ person injured, उसका नाम भी injured में लिख दिया वहां पे, जिसने भी दूसरी FIR में जब उसको अटैच किया. Now against this, he went to the DCP concerned. DCP also did not give him adequate relief, so he went to the Metropolitan Magistrate by filing a criminal complaint under CrPC. Now, Metropolitan Magistrate ordered the police, hearing the complainant, ordered the police to register an FIR. Now, against this order of Metropolitan Magistrate, police went in revision before the session judge. So yesterday, session judge delivered a decision stating that police must register the FIR immediately of this aggrieved person. They also imposed a fine of rupees 25,000 on Delhi police, and also written in their order that the victim is free to file a criminal case against the police officer who did not or declined to register the FIR. So it was on the basis of Lalita Kumari case. After Lalita Kumari case, if the police officer has not registered your FIR, which is disclosing, the information is disclosing commission of cognizable offense, then you can file a case under the provisions of IPC, which is section 166 of IPC, against such police officer. You can also at the same time write to the commissioner or DCP of the police concerned, or SSP of the police officer in charge of the police station concerned, that disciplinary action must be taken against such police officer, and magistrate or session judge can also start a contempt proceeding against such police officer, or you can also initiate a contempt proceeding against such police officer. So after Lalita Kumari case, it's a tough thing for the police officer not to register an FIR if a cognizable offense has been disclosed. Finally, court held that it is a general rule to register an FIR, and not to conduct a preliminary inquiry if offense is cognizable in nature. But in certain cases, police officer has the discretion to conduct a preliminary inquiry. So if the cognizable offense is relating to a matrimonial dispute or family dispute, then preliminary inquiry can be conducted. If it is relating to a commercial offense, kind of cheating and all, forgery and all, then police officer can conduct a preliminary inquiry. If it is relating to medical negligence, a offense committed by alleged to have been committed by a doctor during treatment of a patient, then also preliminary inquiry can be conducted. And if it is a corruption case, then also preliminary inquiry can be conducted, because it is a allegation against a public servant. And if FIR is lodged with a delay of 3 months, over 3 months, then also preliminary inquiry can be conducted. So except these 5 of kinds of cases, if there is some other kind of cognizable offense, police officer cannot conduct a preliminary inquiry. These are the exceptions. So these are the MCC kind of exceptions. So if you want to remember them, these are MCC kind of exceptions wherein police officer has the power to conduct a preliminary inquiry. Such inquiry must be completed within 7 days. However, these 7 days have been increased to 15 days by way of another order passed by the Supreme Court to modify its earlier decision in Lalita Kumari case, and can extend up to 6 weeks. So preliminary inquiry, if it is being conducted by the police officer, it has to be conducted in certain cases: matrimonial, commercial, medical negligence, corruption, and cases where there is a delay in filing an FIR and the period of delay is more than 3 years. So police officer has the discretion to conduct a preliminary inquiry, but that inquiry must be completed within 15 days. But in exceptional circumstances, it can be completed within 6 weeks. So 6 weeks is the upper limit that is fixed to complete the preliminary inquiry. So finally, in Lalita Kumari case, court held that it is mandatory for the police officer in charge of the police station to register an FIR if the information is disclosing commission of a cognizable offense, except in cases of matrimonial disputes, corruption cases, commercial cases, medical negligence, and FIR lodged with a delay of over 3 months. Police officer has to complete this preliminary inquiry within 15 days and or within a period of maximum 6 weeks, which is 42 days. Police officer can also conduct an inquiry in that case also where the information given to the police officer is not disclosing a cognizable offense. So there also he or she has a discretion to conduct a preliminary inquiry. Otherwise, in all cases, it is mandatory for the police officer to register an FIR. If he does not register an FIR and FIR is registered either on the order of SP or magistrate or High Court, then you can file a case against the police officer, file an FIR against the police officer under IPC ka section 166. So tomorrow we will complete other case laws under in your study material. So please go through this case law. The document I have already shared with you on your Google Classroom. If the information is received through internet, WhatsApp और FB, तो वो वाला situation यहाँ पे cover नहीं हो रहा है उस तरीके से, ठीक है? It's basically an idea wherein you are going to the police station to lodge the FIR, mainly covering that area. अगर आप भेज के WhatsApp मैसेज और घर पे बैठ जाते हो आराम से और फिर सीधा ही केस फाइल कर देते हो पुलिस वाले के अगेंस्ट में, so that will not work, ठीक है? But it's an interesting question that how far the dictum of Lalita Kumari stretch. Will it be applicable only to those cases where informant is physically going to the police station to lodge an FIR, or would it be applicable to those cases also wherein in very clear and non-cryptic terms the informant via internet or telephone or WhatsApp message has communicated the information disclosing commission of cognizable offense to the police? Okay? So it's a matter of interpretation how far you can stretch Lalita Kumari ka dictum. Jatin Jyoti Parul